Good morning. How are you all?
Morning, how are you?
Morning.
Are we waiting on anybody?
No.
Okay, what can I do to help you all today?
Yes, sir. Get us off of you. Go ahead, Lacey. Start talking.
That's pretty specific. Miss Kimball?
Yes, sir. Specific.
Go ahead, Miss Kimball.
A custody evaluation was completed, and so we have filed a motion for drug screening and a motion for a psychological exam based upon that custody evaluation recommendations.
Blah, 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 blah.
Before we even get into today's courtroom chaos, let me set the stage, because what you're about to witness is a masterclass in how not to behave in front of a judge. This is a divorce and custody proceeding, which means the stakes are already high. Parental rights, court orders, and long-term consequences are all on the line. But instead of seeing calm legal arguments or strategic positioning, we're about to watch someone systematically sabotage their own case in real time. This hearing involves motions for drug screening, a psychological evaluation, discovery disputes, and deposition scheduling. Pretty standard stuff in contentious custody cases.
Be able to respond in just a second. Miss Kimball, you can go ahead and finish, and then Miss Stiles, you'll have an opportunity to respond in just a minute.
I need to pause the hearing. I don't have an attorney. Can you give me some time to get an attorney? I haven't had adequate time to obtain an attorney, and my attorney withdrawed, and I'm going to need one appointed by this.
That's not an option. There's nothing there unless someone's asking that someone be held in contempt and jailed, which is not something that's set in front of me. Or it's a action by the state to terminate a parent's rights or something like that. Those are the only times I have the ability to appoint an attorney for you.
Okay, then go ahead.
We also had sent discovery out as laid out in our motion sometime back. I had worked with Ms. Stiles' prior counsel and had agreed to 2 extensions, and then we ultimately never got a response, and she filed a motion for protection.
This moment right here is subtle but extremely important. When motions like drug screening and psychological evaluations are raised, they're not punishment. They're tools courts use to determine what's in the best interest of the child. The judge hasn't ruled yet, hasn't accused anyone of anything, and hasn't taken sides. But what immediately becomes clear is the tone problem. Interruptions, sarcasm, and dismissive remarks don't just annoy a judge. They signal unwillingness to cooperate with court oversight. Family court judges are trained to assess credibility constantly. They're not just listening to what you say, but how you say it.
So, Ms. Kimball, are you saying this was something that happened between counsel?
Yes, back in November. We are now setting this hearing is for our motion.
She also represents talking that there.
Okay, so Ms. Stiles, I'll unmute you in just a second. You need to let Ms. Kimball finish what she's saying, and then when you're talking, she'll let you say what you're saying, unless one of you has an objection that is a legal objection. You can't just talk at the other side. So Ms. Kimball, why don't you just go ahead and finish telling me what, so you said that you're wanting a drug screen, so drug test, and do you say psychological or psychiatric? I thought you said
a psychological exam. And then we have an order to compel Ms. Stiles to turn over the responses to our discovery request, to provide dates for a deposition and for attorney's fees for $1,500.
All right, so Ms. Stiles, I'm sending you a prompt to unmute. If you just unmute yourself, you can respond. What is your response to those things? Let's go with the drug screening part. Do you have an objection to taking a drug test?
I'm not going to pay for it because I'll tell you up front I'll fell for marijuana.
This exchange highlights a massive misunderstanding many people have about the legal system. Court-appointed attorneys are not available for civil divorce cases. They are reserved for situations involving potential loss of liberty, criminal charges, incarceration, or certain state-initiated actions like termination of parental rights. The judge explains this clearly, calmly, and correctly that what's telling here is a reaction. Instead of adjusting expectations, the response becomes dismissive. That's dangerous. Judges don't expect litigants to like the rules, but they absolutely expect them to respect them.
When was the last
But
time?
I'm happy to take it
Hold on.
on
When was the last
expense.
time you took marijuana?
I use marijuana daily. All day, every day. And it's legal in what states? California. So we can either get there or not get there. Your choice tonight. I'm glad to take the drug test.
Stop.
Okay, go. It's going to be on his expense,
Stop.
but
Stop. I'm pretty low key. We're in court.
fed up with Miss Kimball.
You need to be respectful.
I'm
So
fed up.
you can just,
Kimball.
if you're gonna use my last name, that's fine. Just say Judge Tanike. Okay, it's pretty easy. So you use marijuana all day, every day.
Not really all day, every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge Tanike.
I'm not interpreting. I just said what you said.
Okay.
What is your response to the request for a psychological evaluation?
Not doing it, and you cannot force me to do it. You cannot physically make me go and show up and partake in anything that I do not want to partake in.
This is the moment where the hearing takes a hard turn. Admitting to daily marijuana use, unprompted, in a Texas courtroom is catastrophic from a legal standpoint. Whether someone personally agrees with marijuana laws or not is irrelevant. The court applies state law, not personal belief systems or other state statutes. Texas does not legalize recreational marijuana, and custody courts take substance use seriously because it relates directly to child welfare. What makes this worse is a casual tone. This isn't a coerced confession. It's volunteered information. Judges don't need to overreact here because the damage is already done.
Do you agree or not agree?
You don't get to ask me questions right now. I'm asking your position.
That's my response to you.
Okay.
You will not get any. I'm not doing a psych eval, and you cannot make it mandatory.
Interesting. In terms of the motion to compel, where they're talking about discovery, what's your response to their motion to compel?
Have you read their discovery? When are you going to view my videos?
Ma'am, you need to answer my question. So I'm going to warn you that it is completely inappropriate to swear like that in court. You need to take yourself, you need to put yourself back on camera. Thank you. I'm not going to allow that. So if you do that again, I'm going to sanction you $100.
Here's where misunderstanding court authority becomes outright defiance. Psychological evaluations in custody cases are absolutely enforceable. Courts can compel participation when mental health is relevant to parenting capacity or cooperation with court orders. Refusing outright doesn't protect you. It escalates the situation. The judge is not asking permission here. He's determining compliance. And the more resistance shown, the stronger the justification becomes for ordering the evaluation. Ironically, the refusal itself can be used as evidence of instability
For every time that you swear in court, because that's not appropriate. You just need to not do it. You can answer the question and be respectful to Ms. Kimball and to the court. And I'm not going to tell you how to answer, but you can just say whether or not you're in agreement with something. In terms of the motion to compel, I haven't heard it yet. So I'm just trying to find out from a cursory standpoint what your position is on these 4 issues so that I can figure out if there are partial agreements or not. It sounds like there aren't. So based upon your response, I'm going to take it that you're not in agreement with their motion to compel. In terms of their request for deposition dates, what's your response to that? I sent you a prompt to unmute yourself.
What dates?
Ms. Kimball, do you have proposed dates?
I would propose.
And whose expense? Mine? Because if it's mine, I'm not fucking doing it. Sanction, give me $100 fee.
This is the pivot from warnings to consequences. Judges don't enjoy sanctioning people, but they will do it to preserve order and authority. Contempt isn't about hurt feelings. It's about protecting the court's ability to function. Profanity, insults, and refusal to answer questions undermine that function. Notice how measured the judge is. He clearly states the rule, explains the penalty, and gives an opportunity to comply. That's procedural fairness. But every additional outburst tightens a noose. Monetary sanctions are often the first step. Continued defiance can lead to removal from a hearing or worse.
I am finding you in direct contempt.
Okay, one fine.
Finding you $100.
Okay, make it 2. Damn, I said 2 words.
Ma'am, I don't think you want to do this. At least the people in the courtroom seem to think you don't want to do this. I will, not because you're requesting it, but because you're not following the order. As I said, sanction you.
Please do.
Let me do it. So that's
Please.
$200.
Here, I'm sure she wants my apartment number, right? Turn it to Miss Kimball. You're going to want.
Stop. That's not something that she asked for. Miss Kimball, what date?
No,
What date?
everybody else.
I would propose August 30th or September 2nd.
Okay.
How long?
Are you wanting how long? That's a valid question. Is it half day, an hour, 2 hours? What do you anticipate?
I would anticipate a full day.
Okay.
So what, the
Ms.
30th or the 2nd?
Yep. Which of those dates works better for you, Ms. Stiles?
What time, dumbass?
You're correct. That is 3.
Yep.
Supposed to start at 9 a.m.
What date?
Stiles, that question is to you. Never
I
mind.
said what
I'm
time?
not gonna let you
Time,
pick.
date? You know, these
I'm not gonna
things.
let you look. You don't get to do this for your own pocketbook. I'm muting you for. So in terms of the request for the deposition, she didn't have any objection. I'm going to note for my own record that she opted out after.
This is the practical consequence of refusing to self-regulate. Once muted or removed, a party loses the ability to advocate for themselves. The hearing doesn't stop. Decisions still get made. Motions still get ruled on. And the absent party has no voice to object, clarify, or defend. Courts view this as self-inflicted harm. You're not being silenced. You're being managed because you wouldn't comply with basic courtroom rules. And when custody and financial issues are on the table, silence is devastating. This case ends exactly how it was headed from the start. Not because of legal technicalities, but because of conduct. The judge didn't rush to punish. He warned, explained, and offered multiple chances to comply. But repeated disrespect, self-incrimination, and refusal to follow basic procedure led to contempt findings and loss of participation. The key takeaway here is simple but powerful. In court, behavior is evidence. How you act informs how the court views your credibility, judgment, and reliability, especially in custody matters.